everybody. I am back again, and I am 10 out of 10 annoyed with StreamYard. If you could, I'm not kidding at all. Please tweet at them and tell them to get their shit fixed, because creators are having to literally reset up streams in the middle of our literal jobs. Like, this is my career at this point. So if StreamYard, who charges me $60 damn a month, could get their shit together, that would be really, really great. In the meantime, if anybody can suggest a competitor to StreamYard that I can happily switch to, I would love that. Thank you. All right. So you're here to talk about Britney Spears. I can't share my screen because StreamYard doesn't know how to act. But if you did catch the last video, which is now unlisted, because why would I have this video compete with the other video? Doesn't make any damn sense to me. Then you will know that we just discussed the concern. I'm so fucking pissed. Like, if there wasn't so many of y'all that really wanted to know this, I would not be going live today. I'm so mad. Like, whenever stuff goes wrong and it's not my fault, I really want to like punch somebody in the teeth. So this is me mad. Okay. Okay. So here is one of 3 filings. And are you going to be able to see all 3 filings today? Probably not, because StreamYard doesn't know how the fuck to act, but I did pay $76 of my own money for these documents. So here's one of them. Now, this has nothing to do with the conservatorship in Hawaii. Why isn't this clicking? What the hell? Oh my God. Am I like literally under technological attack? Is that what's going on here? I am so annoyed. Like, I seriously think I've been hacked. Okay. I can't make this bigger. Don't really know what to tell you. Okay. So what's the name of this document? It's called Britney Jean Spears Notice of Motion and Motion to Quash. Restream is wonderful. I switched months ago. Okay, Heart of Inspiration. Thank you. I will be also switching to Restream and canceling my StreamYard subscription. They're getting $57 a month from me right now, but they're going to be getting 0 because I am so annoyed. Okay. Okay. So Britney's motion to quash, and notice of motion and motion to quash deposition subpoena for business records issued to non-party Kroll Associates, Inc., or alternatively for protective order memorandum of points and authorities. So every time you see a, what's that called? Semicolon, that's like another thing. So this document is all these things, right? It's a notice of motion, a motion to quash, and then if the judge doesn't grant that, alternatively, protective order, and then also it's a memorandum of points and authorities. Okay. To the court. So this is from Britney, right? Britney Jean Spears, notice of motion. Now, this is not a brand new filing, but I have not seen anyone covering it. So it's new, I think, to us. It was filed on April 18th, 2022. It's about 2-3 weeks ago. Okay, so just so y'all are aware of like who these parties are, this Kroll Associates, Inc., I believe, and they're going to tell us in this filing, but I believe this Kroll Associates, Inc. is do y'all know that FBI lady that Britney and Matt Rosengart hired to kind of look into all the alleged crimes and wrongdoing that Jamie and Lou committed? Well, apparently I believe that is what this is right here. The Kroll, I think that's who they are. So let's see. To the court, all parties and their attorneys of record, please take notice that on July 27th, 2022 at 1:30, or as soon thereafter as the matter may be heard, Britney moves pursuant to the laws in California for an order quashing, or in the alternative for a protective order, which would limit Jamie's deposition subpoena for the production of business records issued to non-party Kroll. Now, we do have a footnote. Let's see what that says. Kroll has served objections and joins in the motion. In so doing, Kroll adopts and incorporates by reference each of the arguments set forth in the notice of motion. Memorandum of points and authorities and other material support. Okay. So, excuse me. So what has happened here? Here we are here. What seems to have happened is Jamie Spears has asked to depose the experts, that Britney hired to help her figure out what Jamie did, right? So Britney and Matt go to Kroll, they hire them, they say, hey, look, we need help figuring out what Jamie did, figuring out the finances, et cetera, et cetera. And so now Jamie's saying, oh, well, if you're going to do that, then I want to see all these records from that company. And Britney is basically saying, no, you're not getting records from the company. You're not getting records from anything. And this is my motion to the court to tell why you shouldn't get those records. Okay. So this motion that Britney is filing is brought on the grounds that the subpoena is so the subpoena would be that which had been issued by Jamie and his lawyers, right? They gave a subpoena to Kroll and Associates. Hold on, because as if this isn't enough of a clusterfuck, my cat is screaming her ass off, so hold on. No, it's enough. I swear to God, y'all better be so happy I love you, because I want to do nothing but throw this computer through the wall. Okay. Violence is not the answer. Okay. Extremely overbroad. Okay. So what are Britney and Matt saying about this whole thing? Okay. Well, first of all, it's completely overbroad. What Jamie's trying to get from these people is absolutely overbroad, unduly burdensome, and oppressive. Importantly, Jamie seeks business records from Kroll. It seeks, oh, sorry, that says improperly. When I'm mad, I can't even damn read. Okay. It seeks documents or information containing private, investigative, and confidential information. And it seeks documents or information that are equally available to Jamie, the party whose misconduct is at issue, who is the person most knowledgeable regarding that misconduct. And Kroll was retained by Matthew Rosengart as a consultant. The subpoena, therefore, improperly seeks to invade the attorney-client privilege and the work-product doctrine by seeking documents that are protected by the attorney-client privilege and attorney-work-product doctrine. Specifically, Britney seeks an order from the court that quashes, which means gets rid of, completely annihilates, the subpoena's request for production. And these are all the numbers that Britney doesn't want to have to answer. 2, 3, 4, 5, 6, 8, 9, 10, 11, 12, 13, 15, 16, 17, 18, 19, 20, 21, 22, 23, 24, 25, 26, and 27 in their entirety. And Britney wants to limit the scope of numbers 1, 7, and 14. Given the above, and that, among other things, the subpoena, that's Jamie's subpoena, explicitly seeks materials from a consultant that are protected by attorney-client privilege and the attorney-work-product doctrine, Jamie's subpoena should be quashed to eliminate almost all of the requests in their entirety. To the extent a protective order is requested, that may not be read as a concession of the subpoena should not be quashed. Okay. So basically, she's saying, look, here's the questions at issue. Basically, every single one from number 2 all the way through 27. Number 1, 7, and 14, I can answer some of it, but essentially the whole thing needs to be quashed because this is not information that Jamie needs to be asking Kroll because he has all this information his damn self. Okay. Counsel for Britney, that's Matthew Rosengart, requested and attempted to meet and confer with Jamie's lawyers on the phone, but his lawyers declined to agree to a timely, Jamie's lawyers declined to agree to a timely appointment with Matthew Rosengart so that they could meet and discuss it out. And they also declined to agree to an extension until April 25th so the parties could meet and confer. So that demonstrated how it would just have been futile for us to further attempt to resolve this outside of coming to the court. This motion, meaning Britney's motion, is based upon this notice of motion, the accompanying memorandum of points and authorities, the declaration of Matthew Rosengart, and exhibits, the pleadings, papers, and other documents on file in this matter. All matters upon which judicial notice may be taken in the argument of counsel at the time of oral argument at the hearing of this motion. Okay. Dated April 18th, 2022. So here's the table of contents. Again, I will try to share the other 2 documents with y'all. I'm not going to try to do it right now because I don't want another PTSD fiasco. I'm just going to go through at least this main document here. But we will see the other things that they did file. Now, this document we're looking at right here is 21 pages long. The other two documents, one of them is like 250 pages or 230 pages, like very, very, very long. So I wouldn't probably be able to read that to y'all anyway. Okay, so here's the table of contents. And I like to just skim the table of contents as a lawyer just to kind of see what's going on, what to expect. And it's kind of like, you know, just like when you're reading a book, like you get the gist of what you're about to see. So the first thing, preliminary statement and summary of argument. And then he's going to go through the procedural history and the present motion and how those fit together. And then he's going to get into the legal argument of the whole thing. The two arguments he's going to rely on are A and B. The court should quash the subpoena. The subpoena impermissibly seeks, oh, that was interesting. Okay, so this is super cool. You can click on, sorry. You can click on these and it'll bring you to where it is in the document. That is really cool. I love technology. Okay, so the two reasons that the court should quash the subpoena, which we will be going in, we're just reading the table of contents right now, is the first, number one, the subpoena impermissibly seeks materials protected by the attorney-client privilege and the attorney work product doctrine, and the subpoena impermissibly seeks discovery from a consultant who is not designated to testify at trial. Now, what I anticipate is going to come in on this part two is this is not, Britney and Matt are going to argue, this is not our expert witness. Maybe if they were our expert witness that we were going to bring to trial to talk about stuff, maybe they could have done some of this stuff, but they're not an expert witness. I think that's where they may go with that. Thank you so much, Anna Lynn, for the super chats. Thank you very much. And then B, alternatively, the court should issue a protective order, and then he'll get into his conclusion. Okay. Then when you're writing a legal memo or a legal memo, you have to include all the cases, right? And this is one that he constantly seems to rely on, this Mueller case, table of authorities. These are the cases and the statutes that he's going to be relying on. Okay, so let's get into this. Memorandum and points and authorities, preliminary statement, and summary of argument. Okay. On July 26, 2021, Britney, through Matthew Rosengart, filed her verified petition for suspension and removal of James P. Spears as the conservator of the estate. After extensive briefing and argument and a lengthy hearing, the court suspended Jamie on September 29, 2021, determining that the conservatorship he had run was toxic and that his suspension was proper and in the best interests of the conservatee. Now, as much as I love Matt Rosengart and all that, this isn't exactly what happened. I was in court. I don't remember the court determining that the conservatorship was toxic. But I go off, Matt. You know, I'm biased. So I'm gonna, let Matt say what he wants, but I have to also tell the truth about what went on here. Okay. After reigning over the 13-year conservatorship, from which Jamie enriched himself by reaping at least $6.3 million from Britney's estate, while paying others close to him tens of millions more, that'd be Lou Taylor, Mr. Spears' reign ended. What is 3? Okay, so Matt tells us in this footnote, this sum is the 6.3 million and the tens of millions is based on unverified QuickBooks information. The total money and benefits obtained by Mr. Spears and others are subject to further investigation. Thank you for that, Matt. Mr. Spears, that's Jamie, has nevertheless continued to importune, I don't know what that means, seeking to harass, intimidate, and bully his daughter, his own daughter, including in connection with issuing improper, abusive discovery, and now an oppressive third-party subpoena that impermissibly invades the attorney-client privilege and the work product doctrine, as further discussed below. Although he has repeatedly and discordantly referred to himself as a loving father, Daddy, Indeed, he and his lawyers spent substantial conservatorship funds, his daughter's funds, totaling more than $500,000 on a media tour to try with futility to convey such an image. The evidence of abuse inflicted upon Britney is manifest. So Matthew Rosengart is saying, okay, look, although Jamie came out and said, oh, I love my daughter, and sent his lawyers on a $500,000, a $500,000 press tour to make us all think that Jamie was this loving father, Matt Rosengart is saying in this filing, you failed to even convince us because the evidence of your abuse is obvious. That's what he's saying. Thank you so much, Tracy, for the super sticker. The abusive discovery that Jamie purports to have propounded, as well as the present subpoena, further prove this point and show, sadly, the pattern continues. And then Matt goes, it has been an honor to represent and seek to protect Britney Spears from further trauma and abuse. In that regard, we respectfully submit that a decent father, a father who truly loved his daughter and wished to protect her, as he claims, would place her interest above his own, as a fiduciary is also required to do. Such a father would show grace and decency and cease and desist from bullying and harassing his daughter. Even if he disagreed with the evidence concerning the trauma and abuse she endured, and even if he disagreed with the specific and credible allegations against him that implicate both civil and criminal statutes, this is what a loving, protective father would do. Indeed, the time has come at long last for Jamie to show such decency. In short, Jamie, first as a father, but also as a fiduciary, should simply move on. He should cooperate and tell the truth rather than obfuscating and stonewalling. He should waive the Fifth Amendment. Oh, I don't know, Matt. I don't know if I would waive the Fifth Amendment. I don't know if I would be encouraging Jamie Spears to waive the Fifth Amendment. So when you waive the Fifth Amendment, y'all know what it is, like plead the Fifth, right? When you plead the Fifth, you're pleading the Fifth Amendment of the United States Constitution. And so what you're saying is you reserve the right not to testify against yourself or incriminate yourself in a criminal matter. As a lawyer, I would not say that anyone should ever waive their Fifth Amendment privilege. I mean, that's especially whenever they most likely have committed crimes or they have been implicated in a crime. Like, I'm not saying Jamie Spears committed a crime, but I am saying it appears to me as though he might have committed a crime. And if that's the case, he better not waive his Fifth Amendment privilege, because then the government will come get him. But again, like my personal bias, yeah, sure. I wish he would waive his Fifth Amendment right. I wish he would. I wish he would go to jail. I wish he would go to prison for what he did. But innocent until proven guilty. And y'all know, I am very strongly supportive of the United States Constitution, in particular, the Bill of Rights, the first 10 amendments. So I don't know, Matthew Rosengart's getting a little carried away. I don't know if Jamie should waive his Fifth Amendment privilege, but I'm glad Rosengart's saying it with his chest regardless. Thank you, Grateful Zebra, for the super chat, super sticker. Thank you. Okay. Jamie should properly and professionally transfer all files, including all communications with his counsel during the conservatorship. That means Matthew Rosengart is asking Jamie Spears to transfer all of his text messages, iMessages, WhatsApp messages, emails, whatever, communications with his lawyers during the conservatorship. He should answer all questions regarding his administration of the conservatorship, including regarding his activities in concert with TriStar Sports and Entertainment. Yeah, I know, Lana. I have a very love-hate relationship with technology. Like, I like what it allows me to do, but I wish it was better at doing its job. You know what I mean? Like, we don't get to like make mistakes as humans. Like, we're held to high standards. And so I feel like we should hold technology to those standards as well. Okay. Blackbox. Okay. So basically Matt is saying Jamie should turn over all his communications, not only his lawyer, but he should answer all the questions regarding his administration of the conservatorship, including his activities in concert with TriStar, that's Lou Taylor, and Black Box Security. He should appear promptly for his deposition rather than hiding. He should then finish his final ministerial duties, submit the final accounting, leave his daughter alone, and move on. This is what a father who truly loved, in quotes, his daughter would do. All of this is particularly true in view of the following. By way of illustration only, even as Jamie enriched himself from the conservatorship, making himself a millionaire at Britney's expense on the heels of his admitted alcohol abuse, inability to sustain a livelihood, long history of financial mismanagement, including tax liens, defaults, failed business ventures, and a Chapter 7 bankruptcy, Jamie stripped Britney of fundamental liberties, worked his daughter to the point of extreme exhaustion, and ran a toxic conservatorship that was born of and seriously tainted by significant conflicts of interest, in violation of, among other things, the California rules of court. And I just have to tell y'all, this is so incredibly validating for me to read, because if y'all haven't been here for a long time, you might not know. Lou Taylor, Britney's former business manager, this one right here that runs TriStar Sports and Entertainment, came to my job at my law firm that I used to work at to try and hire that law firm. And as soon as she got her foot in the door, she started talking to my bosses about making me stop talking about her on the internet. Thank you, Amber. Oh, that's my mom. Thanks, Mom. Thank you, Julie. So it's very validating because the guy I was talking to at my work, his name was Larry. He was the general counsel of my law firm. And let me tell y'all, he was like very, very not convinced that there were all these conflicts of interest. I'll just put it that way. And I told him, I said, Larry, there will come a day. You're going to read it in the newspaper. You're going to read it somewhere and you're going to say, damn, BJ was right. You know what Larry said? I don't know if I'm going to say it. I don't know if I'll use that language. So he was more offended by the word damn than the human trafficking and the conflicts of interest that I was showing him the evidence for. I mean, listen, look, like I told him all this stuff and I was just some crazy little girl at the law firm who just started being a lawyer a few weeks ago. But now one of the most high profile lawyers on planet Earth is saying exactly what I was saying at the time. So thank you, Matthew Rosengart, for validating the shit out of what I've been saying for the last 2 years. I was right. Larry at Winston and Strawn was wrong. Tom Fitzgerald at Winston and Strawn was wrong. Carrie at Winston and Strawn was wrong. And I was right. So I just want to gloat a little bit because I deserve it. I had to step aside from my career, my dream job. I was making a lot of money. We're talking a few commas. Do you know what I mean? And just, no, I'm not going to, no, you can't talk about that anymore. Because I'm talking about it now. And I'm going to keep talking about it. And if y'all want to go to jail, if y'all want to go to court about it, we can go to court about it. Because I'm ready. Thank you, Jacob, for the super sticker. Anyway, back to this. Okay. So look, all this stuff, Jamie did all this. Mr. Spears, through his lawyers, was forced to admit that he borrowed substantial money from TriStar shortly before placing Britney into the conservatorship. And then he hired TriStar as Britney's manager. And despite her supposed incapacity, he sent her on a grueling 97-show international tour and on to other work from which he and others close to him obtained many millions of dollars. Now, look, again, another thing that I have been damn saying, but I'm glad that Matthew Rosengart is saying it because it is very validating. They have people all over the internet that always try to call me a conspiracy theorist. And the only damn thing I'm doing is telling you idiots, the people who are idiots know who I'm talking to. The people who aren't mean to me are not idiots. But the only thing I'm doing is telling y'all what I know to be true from my law degree. I had to spend the money. I had to go to get the education. But y'all shouldn't have to do that to know what's going on. So I give it to you for free. I don't think you should have to go to law school to understand the law. So I've been explaining it to y'all for the last 2 years, what I think is going on. And it turns out I was right. I was right. So let's read this footnote. Instead of seeking to place Britney into a short-term LPS conservatorship, which carries a higher initial burden and a statutory framework that protects conservatees, it presumes that the conservatee's mental health can improve. It contains stringent requirements and protections for Britney. Mr. Spears placed Britney into a long-term probate conservatorship generally intended for those with dementia. Y'all remember that dementia box they checked? Well, here's Matthew Rosengart confirming what I've been saying. Since y'all need Matthew Rosengart to come and confirm what I've said, even though I'm a lawyer, I'm very glad that he has done that because look, I'm right. This conservatorship is for people with dementia whose situations cannot or most likely will not improve, evidently without filing a declaration of incapacity. So they checked the dementia box. What have I been telling y'all since July 2020? Team Con checked the dementia box. And then they said, we're going to file proof of dementia before the hearing on February 4th, 2008. And they never did it. They never filed proof that Britney had dementia because guess what, y'all? Spoiler alert. She doesn't have dementia. You don't need to be a doctor. Y'all, we have got to start using our damn common sense because at this point, it's getting a little out of hand. You don't have to be a lawyer to understand a legal document or the law. You don't have to be a doctor to look at a woman who can remember lines, who can remember and make up dance moves, who can remember things from long ago and short time ago, who all of that. And she doesn't take a doctor to tell that she doesn't have dementia. Okay? Let's use our common sense. I am in a mood today. Okay. As Anthony Palmieri, the incoming president of the National Guardianship Association, an organization representing conservators, recently observed, the existence of the TriStar loan is troubling. And the man said, it makes me wonder where Jamie's allegiance lies. Is the conservator making decisions in the best interest of the conservatee? Or is he making the decisions in the best interest of the business manager who Jamie owed a debt to? And again, here you go, Larry. If you're watching Larry from Winston and Strawn, like I told you last year, about exactly a year ago, it reeks of conflict of interest. Okay. So maybe everybody that don't think that needs to go back to law school, back to business school, and learn what a conflict of interest actually means. Because it seems like the attorney that only been at the firm for 3 months knew it a lot better than anybody on the executive board. Lawrence, Tom Fitzgerald, Carrie. Seems like I knew better than y'all what a damn conflict of interest is. And that's pretty embarrassing for y'all. I'm not embarrassed. I'm proud as shit of myself. I'm in debt and I'm broke, but I have my integrity and y'all can't take that from me. But what do y'all have? Not integrity, because you could apparently not even see the conflict of interest. And I had to stop talking about it. I had to stop talking about it so y'all could potentially get money from Lou Taylor is what happened, buddy. All right. The conservator must avoid, this is a rule of court, right? California Rule of Court, Rule 7.1059A. The conservator must avoid actual conflicts of interest and consistent with his or her fiduciary duty to the conservatee. He has to avoid the appearance. He has to avoid the appearance. Even the appearance of a conflict of interest has to be avoided. The conservator must avoid any personal, business, or professional interest or relationship that is or even reasonably could be perceived as being self-serving. Okay, well, he broke that rule. I am so sorry. That rule was broken. I am willing to say that. The conservator must avoid any personal business or professional interest or relationship that is or reasonably could be perceived as being self-serving or adverse to the best interest of Britney. Well, he probably had multiple conflicts of interest in that way. Additionally, as described in the New York Times detailed and heavily corroborated reporting, which included interviews with a trove of information obtained from brave and heroic, now blackballed whistleblower deemed to be highly credible, Jamie directed or was involved in an intense surveillance operation of his own daughter. According to the whistleblower and according to other evidence, he was spying. The spying operation reportedly included both of the following: placing a secret listening device in Britney's private bedroom and capturing in real time and contemporaneously Britney's private communications, including those with her lawyer, which are sacrosanct under the law. So basically, Rosengard's saying, okay, well, on top of all that other stuff, he also spied on Britney, which is illegal. In addition to these gross invasions of privacy, as the record also demonstrates, and as Jamie himself knows, he also engaged in self-dealing, diversion of conservatorship resources, and misuse or mismanagement of Britney's funds. Finally, while acting as conservator, Jamie was also subjected to a court-ordered DV restraining order resulting from allegations of harassment against or abuse of his daughter's own child or children, which requires him to stay away from them. So again, we've been saying this. I've been saying this 2 damn years. Why is somebody in charge of a conservatorship who he's supposedly allegedly only protecting the assets that are eventually going to be the inheritance of Britney's kids, and he's beating the kids? What? He had an active restraining order against him. I think it was like a 3-year-long one against him, filed by his own grandchildren who are Britney's kids, but he's the conservator of Britney. How does that work? It shouldn't, and it shouldn't. That's how it works. It shouldn't. It shouldn't work. If you can't keep your damn hands to yourself, period, you shouldn't be a conservator. But you dang sure shouldn't be conserving somebody who you beat their kid, allegedly. I mean, listen, is it really alleged? Do courts put restraining orders for 3 years for people that didn't do the thing? I don't know. Requires him to stay away from them. While Jamie's breaches of fiduciary duties and other misconduct are obvious. Okay, Larry, if Larry is watching from Winston and Strawn, can you please read this tonight when you're saying your nighttime prayers? Because I deserve an apology. To be honest, Larry, I might even stop talking about you if you email me an apology. ThatSurpriseWitness@protonmail.com. ThatSurpriseWitness@gmail.com. I would like for you to email me an apology because you know I deserve one. Tom Fitzgerald, I would also like you to email me an apology because you know I deserve one. Carrie, I think it was messed up. They tried to turn you against me, but I want an apology from you too because that was messed up. All right. While Mr. Spears' breaches of fiduciary duties and other misconduct are obvious, he has repeatedly falsely claimed he has nothing to hide and will hide nothing. But he also represented that he would unconditionally cooperate in transferring all these files regarding Britney's estate. He said he would unconditionally cooperate with Britney's lawyers, and he would act with complete transparency without conditions. But despite these unconditional representations, he continues to hide and obstruct. Among other things, Jamie has now failed no less than 3 times to appear for his deposition. Let's read the footnote. See James P. Spears, November 1st, 2021 status report. Pursuant to applicable case law, Mr. Spears himself will be responsible. Rosengard Declaration. Okay, so that's the next document. Never mind. Okay. Jamie's lawyer now objects to Jamie being deposed in LA, where the case, his lawyer and Britney's lawyer all reside, and where much of Jamie's misconduct occurred. but instead now he insists that his deposition occur in Kentwood, where he lives. Mr. Spears can run, but he cannot hide from his deposition forever. And to be clear, although Los Angeles is the logical location for his deposition, Matthew Rosengart agrees to take his deposition in any city or state, including Kentwood. So Matt's saying, you know what? I shouldn't have to go to Kentwood to depose you, you stupid ass, but I will. So that's fine. You want to be deposed in Kentwood? That's fine. Let's go to Kentwood. But you're going to still be getting deposed. Jamie has also failed for numerous months to cooperate by properly transferring all files in a proper and organized manner, as he represented he would do. He has also refused to answer fundamental questions or produce all information concerning, among other things, the following. So these are the things he will not answer questions about. Number one, his alleged role in spying on his daughter, including contemporaneously capturing his daughter's text communications and the placement of a secret listening device in her private bedroom. His approval for payments from conservatorship funds to third parties, Lou Taylor, who were involved in or implemented that spying. Oh, it should have been black box on that one. Also, the total fees and or benefits taken or received by Jamie or any entity in which he had any interest from Britney or her estate. He also fails to answer why Britney's net worth was so, quote, shockingly low relative to her gross earnings of hundreds of millions of dollars during the past decade. He refuses to answer about all the corporate formation documents, all entities created or purported for the purported benefit of Britney Spears or her estate. And Jamie also is refusing to answer and give information about other economic and related questions concerning how he administered the conservatorship he imposed in 2008. Rather than answering these questions and cooperating with Britney's efforts to obtain relevant, fundamental information and answering questions under oath of deposition, which he is bound to do as a fiduciary, by the way, and which he would be obligated to do even if he were not a fiduciary, his intent on harassing and bullying his daughter while obfuscating the facts. He is intent. He is intent on harassing and bullying his daughter while obfuscating the facts. In October 2021, Jamie baldly objected to every single discovery request propounded by Britney. He even refused to provide his name in response to interrogatory. So basically, Matt just got through saying, look, listen, Your Honor, whenever Jamie was removed and all that, he said, I'm going to cooperate. I'm going to give you everything you need. I'm not going to hold you up at all. I'm going to give them everything they need. But Matthew Rosengart's saying, okay, well, that was 6-8 months ago now. And we're sitting here today. And I'm letting you know, Your Honor, when we asked him some questions, he refused to answer every single one. And he went even so far as not even to answer his name. So I think Matthew is trying to show Jamie is not operating in good faith. And he is not operating in a way that he said that he was going to operate, right? Jamie even said he would cooperate, and Matthew Rosengart saying, well, Your Honor, he hasn't done that. And he won't even use his damn name. And we know his name, but that's not the point, right? That's the lengths that Jamie is going to. Further, even as Jamie has incongruously, wow, Matthew, you have a vocabulary, sir, failed to appear for deposition or produce documents and information in a timely, organized manner, he purports to serve on his daughter 145 document requests and more than 75 other discovery requests. This is a further distraction from his misconduct. He now seeks to invade his daughter's privacy, the attorney-client privilege, and the lawyer's work product by issuing a third-party subpoena to Kroll, the investigative consultancy employed by Britney's lawyer, employed by Matt Rosengart, to assist in their investigation. In short, Jamie's reign as conservator and efforts to invade Britney's privacy through illicit electronic means or otherwise ended on November 12th, 2021. Jamie's tactics of trying to intimidate, harass, and bully his daughter should cease. Relatedly, his extremely overbroad, unduly burdensome, oppressive, and improper subpoena is objectionable for many other reasons that we're about to talk about. This motion is necessary to prevent the impermissible invasions of the attorney-client privilege and the attorney work product doctrine, which are held sacred under California law, and for the reasons contained herein, our motion we're filing should be granted. Okay, so here's the procedural history. Suspended conservator Jamie Spears issued a deposition subpoena for the production of business records that purports to require a non-party consultant to divulge privileged information that's protected, divulge privileged and protected communications and documents. California law does not permit Jamie to take advantage of the industry and efforts of Britney's lawyer and their investigative team by peering behind the curtain to discover his daughter's counsel's legal strategy, mental impressions, and evaluation of the facts and law. Okay, so what this little section right here is basically saying is we have rules in this country, like, I don't know, attorney-client privilege, attorney work product doctrine, and just generally like trial strategy. Like Jamie doesn't really have the right to ask us what we're over here talking about. Like that's not how it's supposed to work. This is a third party. This is not someone who is going to be called to the stand. This is not someone who's going to be participating in the case. This is someone that they had to hire to try and untangle the web that Lou and Black Box and Jamie and Vivian Lee Thoreen and Gerald and Geraldine and all of them got all tangled up. And so Matt is saying, look, like under the law, they have no right to this information. The relevant facts are simple. Britney's lawyer engaged Kroll as a consultant. Kroll has not been designated as an expert witness for the trial and has not prepared an expert witness report. Now, this is important because if they were an expert witness that they would be going, to trial, and if they had prepared an expert witness report, then maybe that would be able to be accessible to Jamie. But Kroll hasn't done that. Jamie issued a deposition subpoena to Kroll for the production of business records, a phrase that doesn't actually apply in this context. Jamie requested everything related to Kroll's engagement, research, analysis, communication, interviews, etc. regarding this case. And Matt says this is improper. The discovery statutes do not even permit him to use such a backdoor. He can't do the shortcut piggybacking efforts, much less a suspended fiduciary. He can't seek our legal counsel's legal work analysis and strategy. You can't ask for that. And Matt, to be clear, Matt can't ask for that either. And he's not asking for any strategy about his Jamie's defense. He's just asking for the communication having to do with the conservatorship, which is discoverable. So I know y'all are talking about, where's our question? I don't know whatever happened to her, but she definitely blocked me on Twitter. Somebody had asked a question about the Hawaii conservatorship. I did do a live right before this one, and StreamYard didn't know how to act, so I had to start a new live. That conservatorship has been terminated. So if you go, you can probably find that video if you go through the playlists, but I made it unlisted, so it wasn't competing with this one. Okay. We briefly addressed the only information needed to understand the relationship between Kroll and the parties, the procedural posture that led to this motion, and why and how the subpoena meaning Jamie's subpoena, impermissibly seeks materials that are protected by the attorney-client privilege and the work product doctrine. Kroll, so here they're going to explain who they are. Kroll is a preeminent global investigative and consulting firm with nearly 5,000 professionals located in 30 countries and territories around the world, and is a recognized leader and specialist in conducting complex financial and other investigations. Britney's counsel, that's Matt Rosengart, retained Kroll last summer as a consultant. Okay, so this is important. Why were they retained? They were retained as a consultant. Shireen Ebadi is an associate managing director in the forensic investigations and intelligence practice of Kroll. Before joining Kroll, Miss Ibadi served as a special agent with the Federal Bureau of Investigation, aka FBI, where she worked on complex financial fraud and public corruption cases for more than a decade. So she worked at the FBI. She was highly regarded and highly decorated as a special agent with the FBI. During her tenure with the FBI, Miss Abadi received the FBI's Medal of Excellence and the FBI's Excellent Performance Award for outstanding service. She also received multiple prestigious United States Attorney's Awards for exceptional assistance provided to the Department of Justice in various financial fraud prosecutions. And she received the Valedictorian Award for graduating at the top of her class. Miss Ibadi was also selected by former FBI Director Robert Mueller to serve in his special counsel prosecutor's office in Washington, D.C., during which time she served with distinction, helping to obtain the federal convictions of Paul Manafort, which was Donald Trump's former campaign manager. As a consultant and former federal investigator, Ms. Ibadi, along with a team of Kroll forensic accountants and analysts, has been analyzing issues relating to Jamie's gross mismanagement of the estate and potential violations of state and federal law. Although Jamie was previously suspended and the conservatorship is over, and despite profiting personally from his daughter's estate in an amount exceeding $6.3 million, we do not conclude in that figure monies or benefits that may not have been disclosed. On December 15, 2021, Britney filed a petition seeking to have her, This is incorrect. On December, it should read Mr. Spears filed a petition seeking to have Britney, and this is why, Matt, this is why I tell you to just use people's first names, because even you and your associates have now messed this up, and it's unclear, and it makes your writing unclear. So I understand that it's kind of like old school, like writing style or whatever that you do, where you have to say Miss Spears, Mr. Spears. But first of all, it's very confusing for the reader. Second of all, you can't keep it straight, clearly, because look, you've now miswritten here. So please, every time I read one of your filings, I ask you, Big Sloppy already does it. So you just go do what he does. Put people's first names. There's too many Spears, and clearly y'all can't even tell it apart. This isn't a read. I mean, it's just the truth. So what this should say is, on December 15th, Mr. Spears filed a petition seeking to have Miss Spears, meaning Britney. And look, could that be Miss? Could that be Lynn? Could that be Britney? That's the thing. It's weird. So just use people's first name for the love of God. Please, for the love of God. Okay. So on December 15th, Mr. Spears, that's Jamie, filed a petition seeking to have Britney continue to pay his legal fees going forward. Jamie's petition is legally meritless. So he got it right on this sentence, but it should have said Mr. up here. Under the totality of the circumstances, his petition is also morally abominable. Among other things, California law understandably holds. Oh, sorry. I'm sorry. Thank you so much, Melody. Oh, I don't know what that is. I never heard of that in my life, but thank you for the super chat. Okay. Among other things, California law understandably holds that pendente lite fees are not justified where, as here, the fiduciary's misconduct is at issue. Thus, on January 14th, 2022, Britney filed her objections and her opposition to Jamie's petition for an order having his attorney be paid. Okay, so what Matt is saying is, Your Honor, Jamie filed a petition wanting Britney to pay for his lawyer fees, and Britney filed a few weeks later in opposition to that, and we had a lot of good reasons because that was stupid, and there's no reason why Britney should be paying his fees. Okay. On or about March 1st, 2022, Jamie served a deposition subpoena on Kroll for production of so-called business records. The subpoena, and they've called that the subpoena. The subpoena contains 27 requests asking asking Kroll for everything under the sun relating to the Ibadi Declaration, Kroll's engagement, and Britney's legal strategy. Under the guise of non-party discovery, the requests improperly seek impermissible access to confidential, investigative, private, privileged communications, and attorney work product. For example, look at Exhibit C, a subpoena request 21 that says Jamie had asked for all documents relating to any draft or final opinions, analyses, reports, and evaluations that Kroll prepared or are preparing or intend to prepare in connection with the conservatorship proceedings, or Jamie. And request number 27, they request all communications with Britney, including without limitation her counsel, notwithstanding Jamie's prior actions as conservator, including those revealed by the New York Times. Jamie's unlawful access to private communications will no longer be countenanced. So basically, Matt's being a little sassy here, and he's going, look, listen, he might have like illegally gotten a hold of Britney's communications and my communications, etc. before, but that shit ain't going to happen no more, is essentially what he's saying. Thank you so much, Tracy, for the super sticker. Oh, it's a cream that, it hides bruises. Oh, maybe I need that. All right. I have not been keeping up with the Johnny Depp and Amber Heard trial because, to be honest, literally none of y'all know how to act. Y'all all have your mind made up on the case already. So that leaves me with no room to analyze. And you know me, like, I really do like to go on both sides, even here, right? Even on Matthew Rosengart, I'm calling him out on the things that I find issues with. But if I were to come on here and start talking about Johnny Depp and Amber Heard and give y'all my true opinion, my legal middle of the road opinion, half of y'all would unfollow me because you literally don't know how to act. But we're working on it together, right? Hopefully all together, we can all start to have a little bit more of an open mind and start to really consider what the evidence is that we're looking at, and not just what the media is telling us, or not what each respective celebrity's PR team is trying to tell us to do, right? Anyway, I feel exactly the same way about the Kyle Rittenhouse case, but exactly for the opposite reasons. I didn't feel comfortable to talk about my feelings about that case to y'all because y'all don't know how to act. Some of y'all do know how to act, but eventually we're going to have a big enough group of people knows how to act that I can talk about those cases. For now, we're just going to be doing this. All right. Now we're on to the next section called legal discussion. The court should quash the subpoena. So remember, we looked in the table of contents. This is A. Trial courts have broad discretion to curtail improper and burdensome discovery. Curtail means like stop it, right? So trial courts have a lot of discretion to stop BS discovery requests, essentially. Judges also have broad discretion in controlling the course of discovery. To that end, the Discovery Act provides that a court shall restrict the use of a discovery method in the following case: where it is unduly burdensome or expensive, taking into account the needs of the case, the amount in controversy, and the importance of the issues at stake in the litigation. The court likewise has authority to quash a deposition subpoena entirely. It also has authority to modify it in order to protect against unreasonable or oppressive demands. The court also may make any other order as may be appropriate to protect a person, such as Britney Spears, from unreasonable or oppressive demands. In addition, the court may order that a certain matter. In addition, the court may also order that certain matters may not be inquired into, or that the scope of examination has to be limited to certain matters. Of particular note here, in view of the trauma and abuse endured by Britney, Subdivision B also authorizes the court to make any order that justice requires. So he's basically just giving the court all their different abilities, right? He's saying, look, here's all your powers. First of all, you have the authority to quash an entire deposition subpoena. Second of all, you can also make any other order that's appropriate to protect Britney from unreasonable or oppressive demands. You also have the authority to tell him that they can't ask questions about certain matters completely, and you can also limit the scope of the examination. Also, Your Honor, you have the authority, because there's trauma and abuse involved, to authorize any order that justice requires to protect Britney or anyone from unwarranted annoyance, embarrassment, oppression, or undue burden or expense. Here, the court should exercise its broad authority over the subpoena for at least 3 related reasons. Okay, here's the reasons why the court should exercise broad authority. First, the subpoena seeks private, investigative documents and materials that are also protected by the attorney-client privilege and the attorney work product doctrine. Second, Kroll is a consultant that has not been designated as a testifying expert, right? Remember that expert witness report thing? And finally, as referenced above and in the accompanying objections, the subpoena is abusive, designed to cause unwarranted annoyance, embarrassment, and undue burden and expense. And then this is attached to the footnote here. Okay. A1. The subpoena impermissibly seeks materials protected by the attorney-client privilege and the work product doctrine. The attorney-client privilege has been a hallmark of Anglo-American jurisprudence for almost 400 years. Oh, I think he forgot to put his citations in. Oh, no. Matt, did you forget to put citations? Oh, boy. Oh, no. This is really embarrassing. This is something I would do, to be honest. When you're writing a legal memo, you have to put, like, this is a citation, right? When you're writing it. So look, you write a sentence and you tell the court where you got your sentence from. The public policy fostered by the privilege seeks to ensure the right of every person, blah, 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 blah. How did you get that? Oh, it was from this case called Zurich American Insurance, blah, blah, blah. But up here, when you're just drafting it, you just will write sometimes like citations and you go back and put your citations in. It looks like they didn't do that. That's a rookie mistake. That's kind of embarrassing. Clearly, the fundamental purpose behind the privilege is to safeguard the confidential relationship between clients and their attorneys. But listen, like, it doesn't matter. Like, he is right. This is right. This is very widely accepted. This isn't like, he's lying. It's not like bad. It's just like more like a form, bad form. In other words, the public policy fostered by the privilege seeks to ensure the right of every person to freely and fully confer and confide in one, having knowledge of the law and skilled in his practice or her practice, in order that the former may have adequate advice and proper defense. It is fundamental that the attorney-client privilege includes communications with third persons who are present to further the interest of the client in the consultation, or those to whom disclosure is reasonably necessary for the transmission of the information of the accomplishment of the purpose of it. So basically, he's just saying the attorney-client privilege is fundamental. And on top of the attorney-client privilege, in connection with it, there is a privilege for the attorney to hire these third parties. And in this case, the attorney hired Kroll. It is part of the attorney-client privilege that Jamie cannot see what I talked about with Kroll, because that's the attorney-client privilege. That is basically what is the argument that Matt Rosengart is making. Thus, when a party has engaged a consultant or a consulting expert, the attorney-client privilege applies to communications made by, the client, in this case would be Britney, or the attorney to the expert in order for the expert to properly advise the lawyer, right? So he's saying that what I just said, the attorney-client privilege is included whenever an attorney hires a consultant. A communication, okay, it follows to the communications of the attorney's agent, that would be Kroll. Yes, the attorney's agent, that's Kroll, to the attorney, that's Matt Rosengart, are within the privilege. So he actually does cite that there. So they're saying, look, here's all these cases that have already been decided, that whenever an attorney is talking to a consultant, the other party, the other side cannot request those communications. Then he says another case, People versus Meredith, also instructive on this point. In that case, Meredith, the court explained that the attorney-client privilege applied and was preserved when an attorney shared confidential communications with the retained investigator. Because if the investigator was to perform investigative services for which the attorney had retained him, it was necessary that they have to be able to see the confidential information. So basically, this case, Meredith, essentially says, if the attorney gives somebody else confidential information, but the purpose is for them to that person to investigate the situation, it doesn't break the attorney-client privilege because it's necessary. It's reasonably necessary that you need to be able to share certain confidential information with experts that you're never going to want to share with the other side. You need to hire experts sometimes. The court further reaffirmed that because the investigator then is a person encompassed by the privilege, he or she stands in the same position as the attorney for purposes of the analysis and operation of the privilege. The investigator cannot disclose that which the attorney could not have disclosed. Okay. Finally, the court held that the attorney-client privilege is not strictly limited to communications, but it also extends to protect observations made as a consequence of protected communications. Among other things, the present subpoena generally seeks such privileged communications between Kroll and Ms. Spears' lawyer for information or materials obtained at the direction of counsel. Jamie's subpoena should be quashed or at minimum limited for this insurmountable reason alone. Also, California law protects from discovery a writing that reflects an attorney's impressions. So basically notes. Also, you can't ask them for anything about their notes. Additionally, even when attorney work product does not reflect impressions, conclusions, opinion, legal research, or theories, the work product is still afforded qualified protection. It is not discoverable unless the court determines that denial of discovery will unfairly prevail. Okay, so he just keeps driving the same point home. And now he's giving an example. For example, California law holds that witness statements obtained as a result of interviews conducted by an attorney or by an attorney's agent at the attorney's behest constitute work product. The fundamental rules, these fundamental rules further California's legislated public policy to preserve the rights of attorneys to prepare cases for trial with that degree of privacy necessary to encourage them to prepare their cases thoroughly. Okay, so also the lawyers have a privilege, right? They're just given every single thing that should say why to quash this subpoena. And he's saying, contrary to all these principles and contrary to public interest and the interest of justice, the subpoena, Jamie's subpoena, explicitly and improperly targets protected work product. They give an example: all documents related to any draft, final opinion, analysis, reports, and evaluations that Kroll prepared, are preparing, or intend to prepare in connection with the conservatorship. Okay. Also, the subpoena impermissibly seeks discovery from a consultant who is not designated to testify at trial. So this whole part is basically just saying it's not an expert witness. They're not going to testify at trial. So that's another layer of reasons why they don't have the right to see what we're doing. Alternatively, the court should issue a protective order. Although the subpoena should be quashed as a matter of law, we alternatively request that a protective order be entered to narrow the scope of the subpoena and preclude discovery of the privileged and protected work product. In conclusion, for the foregoing reasons, we respectfully submit that the court grant this motion and enter an order quashing the subpoena. Now, importantly, I haven't seen anything be filed in Britney's case since this was filed. So it seems like maybe they're trying to sort it out in the back. Maybe they're trying to sort it out. Maybe the court doesn't really know what to do. But that's basically what's going on there. Now, let me see if I can share the other documents. If it doesn't let me, I'm going to be annoyed. Let me see. Oh, look, it's letting me. Okay. So this is the first. Again, I paid like $76 for this. Hold on. So here's the declaration of Matthew Rosengart. Like I told y'all, we're not going to. Oh, wait. It's not showing. Let me see. Can y'all see this? Oh, share. Okay. So this is Matthew Rosengart's 282-page declaration. I will just put this up on my Google Drive if y'all want to look at it. But the reason that it's so long is these exhibits. So Exhibit A is, look, they tell us. Exhibit A, Britney Spears' objections and opposition to Jamie's petition for an order regarding payment. Exhibit E is an email exchange between Matthew Rosengart and Jamie's lawyer. Exhibit C is Britney's objections to the subpoena. Exhibit D is Kroll's objections to the subpoena. Exhibit E is the Second Amendment notice of the deposition of Jamie Spears. And then the surveillance apparatus that surrounded Britney Spears is Exhibit F. And then another newspaper article is Exhibit G. Okay, so Exhibit A, we probably already read that. These are the, oh, we haven't read this. So I'm going to have to like just read this to y'all later because this is long and I'm getting tired. But we do have a chart here that we can look at of Jamie's expenses. So look, despite putting himself as a volunteer for the role of conservator, Jamie commenced the conservatorship and siphoned millions of dollars from Britney's estate for over a decade, taking fees, commissions, and other miscellaneous payments totaling more than $6 million in known funds, as set forth in the chart below. So this is Jamie Spears Management, Inc. $153,292 in 2011, $1.8 million, $192,000, $550,000, $500,000 in 2018, right? Like this is how much Jamie Spears Management, Inc. siphoned off from Britney's conservatorship, $6.3 million. That's just this company. We don't know any of the other companies, any of the other amounts. His lawyers were paid many millions more. By way of example and not limitation, his prior litigation counsel, that's Vivian Lee Thureen, recently sought fees of over $1.3 million for a 7-month period, including approximately $540,000 for supposed public relations work for Jamie Spears. So let's keep moving. This is all still Exhibit A, I think. Let's see. Again, this is like 200, Exhibit 1 of Exhibit A. So this is a transcript. Yeah, this is just like so long. I don't know if we're going to. This is a transcript. Those are very long. Okay, Exhibit 2. So this is a letter from November from Matt Rosengart to Scott Edelman. We write in response to the above reference matters. So it was like, this was a letter about TriStar and Robin Greenhill's failure to show up with for their depositions, failure to produce emails and text messages. Again, this is just all like, this is a 280-page document. So I'll just post them all on the Google Drive and y'all can take a peruse through there. But essentially what Britney is saying is Jamie Spears is trying to get a hold of her consultant's business records, which is not allowed under the law. And that's basically the whole filing. There's a lot of other little tidbits and things. It's very validating that everything that I was saying for the last 2 years is just still coming true. And I was right. And everybody that told me that I was a conspiracy theorist was wrong. So there's that. But yeah, so I have like a lot of other things to do today. I'm going to get going. For those of you who are keeping up with the Bam Margera conservatorship, we have requested the additional documents and the additional, communications, etc., from the Pinellas County Police. And we're hoping to get those within the next 2 or 3 weeks. And I'll let y'all know what's going on with that. If anything else is filed in Britney's case, I will come on and update y'all eventually. Yeah, thanks for stopping by. Thank you all so much for the super chats. I can't wait to come back. See y'all later. See y'all again. Make sure that you are subscribed to BJ Investigates and Deep Dive because we have some things coming. We're not going to tell you when, but it's soon, and I think you're going to like it. So those are linked below in the thing, and make sure you're following that. Vaccine defamation.